and we are here for oral argument in case 29581. That's State of Ohio versus Jovonta Delmar Moore. The appellant may reserve up to 5 minutes for rebuttal. If you wish to do that, just let me know before you begin your argument. I'm going to do my best to keep you apprised of your time. The arguments are being visually and audibly recorded. They are streaming live as I speak. Please recall, do not use the names of any victims. I know that there are a lot of other people involved in this case, so do your best to use initials or some other designation. We have read your briefs and we are ready to begin when you are, Mr. Armstrong.
Thank you, Your Honor. May it please the court, my name is James Armstrong and I represent Jovonta Moore in this matter, and if I could reserve 4 minutes for a rebuttal.
All right.
Your Honors, this is a sad case. There is a young man currently serving prison time for a crime in which, on the night in question, he was simply trying to have dinner with his family members, his children, their mother, their grandmother, where they lived. My client, for probably the previous week, was constantly pestered by the decedent in this manner, who did such things as, on the 25th of March, was chasing him along with his children, the children's mother, and their grandmother in a car around Akron. The decedent showed up that day with another individual carrying a gun, trying to instigate another fight. The night in question, even the state's own witnesses indicated that the decedent showed up and was looking for a fight on the night when, again, my client was simply having dinner with his family. There's some distractions in the case. It seems to be undisputed that my client, probably a week before this, did have another confrontation in which he fired his gun, which he was carrying, and I don't see there is anything in the record indicating he wasn't allowed to carry a weapon, in a manner that was not smart, but certainly wasn't meant to specifically injure anyone, or perhaps let the person, the decedent, know that he would hopefully be able to protect himself. The keys to this case, I think, are twofold. One, whether Mr. Moore acted in self-defense on the night in question when he was literally harassed out of a house when he was simply having dinner, where he was invited and the decedent was not. The other situation is, in reading through the transcript, the first thing I noticed was my surprise that this case was not indicted as an aggravated assault and manslaughter, since the facts of the case, even if we assume the self-defense argument wasn't sufficient for the jury to accept, certainly the aggravated assault and thus a manslaughter conviction more fits with what actually the testimony was. We have serious provocation on an ongoing basis by the decedent. We have a person who did not seek, in Mr. Moore, who did not seek out the decedent, in the fact that he wasn't chasing the decedent, but the decedent was chasing him. My client wasn't over at the decedent's home while he was having dinner. The decedent came uninvited and unwelcome into the family home where my client was having dinner with his children, their mother and their grandmother and other family members, and was essentially refusing to leave when the grandmother of his children essentially ordered both of them out of the house because of the confrontation deliberately, intentionally caused by the decedent. I'm somewhat surprised in two ways. I'm not a big fan of filing motions for ineffective assistance of counsel, but I was very surprised that trial counsel did not request that specific jury instruction. And based on the testimony, I was actually surprised the trial court didn't on its own, because I think they have an obligation to do so, present that option to the jury. I think in the fact that the jury did not find that there was a purposeful killing in this manner. That was the initial indictment, count 1 for murder. They were thus left with either letting Mr. Moore walk and completely acquit him based on a self-defense fine, or into a felony assault case and thus a murder conviction, which the facts actually don't make sense when you think of all the things the decedent did leading up to the shooting on the night in question. And this includes even the state's own witness, who somewhat changed her story a little bit while on the stand, according to the testimony or the transcript, in which she initially said that the decedent reached towards the Mr. Moore as they left the steps. And that was after, I believe there's testimony that he was driving the prosecutor's witness's car and essentially blocked it in. It was apparently one of his girlfriends, the decedent's girlfriends, because it appears that he had not only was dating this other person who testified, but also the mother of my client's children. This is the reason why during our brief and that I focus not only on the self-defense, but significantly upon the aggravated assault elements and the manslaughter elements. I mean, this goes back to the difference between murder and manslaughter. One is sudden passion, the other is certainly more intentional, which dates back obviously to William Blackstone and his commentaries on the laws of England, that separated, I think, first manslaughter from murder, and the weakness of the heart being murder and the sudden passion being manslaughter. There is no indication that Mr. Moore was ever seeking out the decedent to harm him. He, after that initial thing, which in my opinion the state introduced solely as a distraction, and to try to take away from the fact that after that fact, we have 3 separate instances in which the decedent deliberately and intentionally went after Mr. Moore. The first one was in a car chase. That afternoon, he went over to his house with his gun-toting associate. And then on the Sunday night, when they were having a Sunday night dinner, when the decedent angrily went over to the house driving, his other girlfriend's vehicle, or I don't remember in fairness whether he drove her or she drove him over there, and then he barged into the house, again, not being invited and unwelcome. How we did not allow the jury to even consider that type of provocation, and the lesser included, and aggravated assault has been established as a lesser included of felonious assault for many years. It denied Mr. Moore due process, and thus he is essentially sitting in prison right now for a crime in which the facts are not commensurate with, as opposed to had the jury been given the option of recognizing the quite candidly despicable behavior by the decedent leading up to this event. I point to the simple fact that had the decedent not gone over to this house uninvited and unwelcome, barging into the home during a family dinner, he essentially created the very circumstances that led to his own death.
Counsel, the twice you have mentioned that the decedent barged into the house. My understanding from the briefs, and I have not yet read the transcript, but my understanding is this altercation took place when the defendant was standing on the front porch and the decedent was somewhere near the porch or on the steps of the porch. Am I incorrect?
Your Honor, yes and no. The final act of the play, shall we say, was on the steps of the grandmother's house. And when I say grandmother, I'm talking about my client's children's grandmother, just to try to identify the people in respect to Judge Callahan's admonition about avoiding using names. But prior to that, we have the decedent showing up, and this will be clear in the transcript, showing up angrily at the home because he couldn't get a hold of the mother of my client's children, who was apparently one of his girlfriends. coming into a house. There's no question there was a family dinner going on. There's no question my client was an invited individual there having a Sunday dinner with his children and their grandmother and their mother, along with other family members. And it's no question that the grandmother essentially got fed up because the decedent was refusing to leave. He created the confrontation that very night. So what, Your Honor, what you're focusing on is after the grandmother got tired of the confrontation that was specifically created by the decedent and told them both to just get out of my house because she was kind of fed up with it. And at that point, the decedent goes out first, and then that's where you have some disputing testimony in the transcript as to what exactly happened. According to the testimony initially of I think the first witness, who was I think one of the decedent's girlfriends, the one who drove him over there, she initially indicated that he had reached out, turned and reached towards my client, who was a couple of steps ahead. And at that time, my client fired his gun, I believe, 3 times. And I believe the state indicated there were other, in their brief, in a matter of fairness, there was some disputing testimony based on what people said in the days following and what they testified actually when they were put under oath during the trial. So that's kind of, hopefully I answered your question, but this is a culmination of that pretty much started a few days earlier than the night in question, but on the certainly on the 25th, which is almost a week before this happened on March 31st of 2019. On March 25th is the time that the decedent chased them in a car. And in the vehicle, it was the grandmother, the children, the mother, and my client, and then came over to the grandmother's house with a gun-toting associate. And then on the 31st, he shows up with the with his other girlfriend, and just comes in the house trying to create a conflict. And this is the reason why.
Armstrong, excuse me for interrupting. I just want you to know you've started into your rebuttal time. It's up to you. You're welcome to continue.
All right, I will just wrap this up and reel there. So it was clearly every indication of this matter was the thing that started this whole thing was the decedent's behavior. And I'll reserve the rest of my time for rebuttal. Thank you, Your Honor, for mentioning that.
Whenever you're ready.
Thank you, Your Honor. May it please the court, I'm Jacqueline Corrigan on behalf of the state to urge this court to affirm Mr. Moore's convictions. There really are 3 questions before this court today. First, did Mr. Moore shoot the victim in this case in self-defense? Second, did he shoot the victim in defense of others, as he has raised in his appeal for the first time? And thirdly, which counsel seems to have been focusing on in this oral argument, was did the victim's efforts to get into a fist fight with Mr. Moore, is that a serious provocation that's legally reasonably sufficient to have incited Mr. Moore to shoot him? The evidence in this case overwhelmingly says that the answers to each of these questions is no. And that's based not on the law as the defendant would like it to be, but on the law that it is actually today, regardless of one's perspective. And I would remind the court of a few points. Yes, the state has never backed away from the fact that there was an ongoing feud between these 2 parties, Mr. Moore and the victim, that had been going on for about 2 weeks. They were both participants in that feud. Mr. Moore had fired shots. The decedent had sought to have a fist fight with him on many occasions. And yes, he was at the grandmother's house seeking to have a fist fight with Mr. Moore. I would remind the court that the only party on that night, and it's only that night that is the salient point in this case, that the only person with a gun with the actual power in this situation was Mr. Moore. And what is key to keep in mind is not so much the background of the feud between these two parties, but what's important is, what did Mr. Moore perceive, what did he feel, and what would be objectively reasonable in terms of his fear at the time that he pulled the trigger. Because there are three elements of self-defense, and it's not just what the decedent did. In fact, that doesn't really even come into play. The three elements are, did Mr. Moore take part in creating the affray? Okay, maybe he did not, but he still, any of these other elements is key to whether he acted in self-defense. Did he have, for instance, a bona fide belief that he was in imminent danger of grave bodily harm or death, both objectively in terms of a reasonable person, namely a jury, and subjectively, did he have an honest belief on his own? Also, did he have a duty to retreat in the situation that he violated? Yes, he did have a duty to retreat. The castle doctrine does not apply in this case because Mr. Moore was not in his own home at the time when this incident took place. He was outside on the grandmother's porch where he could have retreated within her house and ended the entire affray, but he did not. He also did not call the police. He also shot the victim in this case, not once, which would have ended the affray, but he shot him 3 times. And there is case law that we've cited in the brief that if a person fires not once but multiple times, after that first shot, the danger is eliminated. The second and third shots are not justified. And I would remind the court that this whether somebody acted in self-defense or in defense of others is not subject to a sufficiency argument or a sufficiency analysis. But Mr. Moore violated his duty to retreat, and his testimony itself negated.
Attorney Corrigan,
Yes.
I'm sorry. I scratch my head over this because I wonder, under the change in the self-defense, there is some school of thought. I can't recall the case, but I know the 10th district, it's even like in a footnote, made some reference to perhaps because of the change and the burden shifting now that it is subject to sufficiency.
Actually, Your Honor, I had found some cases, including State versus Hancock from the Ohio Supreme Court, but more importantly, there's a case out of the 5th district, and that's State versus McBride, and that's from this year, from earlier this year, that held that self-defense and defense of others were, and also other affirmative defenses like them, are not subject to a sufficiency analysis. And if you look at what self-defense is, it's where you're admitting that you committed the conduct, but you're saying you had a justification for it. And since the justification is subject to the credibility of the defendant, and it's subject to the credibility of the other witnesses, because credibility is not part of the sufficiency analysis, then it means that proof of these affirmative defenses can't be subject to a sufficiency analysis. So I think logically it makes sense what the Ohio Supreme Court had said in Hancock, but more importantly, what McBride has said out of the 5th district earlier this year. And I hope that addresses your question.
It does, thank you.
Okay. But to continue, Mr. Moore's testimony negated any kind of bona fide belief that he was that he had a fear that he was imminently in danger of great bodily harm or death from the decedent at the time. He testified he had very little, if any, subjective fear, but objectively, what he said was he didn't know what the victim might do. The victim only threatened a fist fight with him. Whereas, again, Mr. Moore was the one with the gun. The victim did not behave as if he were armed. Mr. Moore did not wait to see whether the victim was armed. He didn't wait to see what the victim would do. He actually testified that he thought that the victim might slap or punch him, not shoot him. And again, he fired 3 times. at the victim. And so any danger of imminent grave bodily harm from this victim ended after that first shot. And I would also remind the court that Mr. Moore testified that he kept firing even as this victim was falling to the ground. Now, regarding the argument that was never made before the trial court concerning a serious provocation sufficient to incite deadly force, which would be necessary for an aggravated assault or a manslaughter charge, there's a two-part test for whether that provocation is sufficient. It has to be objectively sufficient to arouse the passions of an ordinary person beyond the power of their control. And then it also must have subjectively actually done that to the defendant. There's a reason why counsel at the trial level never brought this up, and there's a reason why the trial court could not sua sponte have a jury charge on either of those lesser included offenses that Mr. Moore wishes he had had today. And that is because there was no evidence at all that there was any kind of overwhelming passion or rage that Mr. Moore experienced at that time. He did not testify to that. He had the opportunity and he never did. Instead, all he testified to was he didn't know what the victim was going to do and he shot him anyway. So that's not an overwhelming passion or rage. He was in control. He knew what he was doing. In fact, he was on his cell phone when he was when he began pointing the gun at Mr. Moore. So it's axiomatic in Ohio that you have a jury instruction when two things are present. When, first of all, that jury instruction is a correct statement of the law, but more importantly for this case, when the jury instruction is justified by the facts. No jury instruction concerning any of the lesser included offenses that Mr. Moore wishes he'd had today were justified by his own testimony. So without it being justified by the facts, the giving of an instruction like that would have been an abuse of discretion by the trial court. And without having those kinds of facts upon which to base a request for a jury instruction, you can't fault his counsel for not attempting to raise an argument that would have been futile. So none of these things actually justify a reversal of Mr. Moore's conviction or a new trial. And so essentially those are the arguments of the state, and those are the reasons why the state is asking you to affirm Mr. Moore's conviction. And unless the court has any questions for me, any additional questions, the state of Ohio would rest on its briefs and again, respectfully ask you to affirm Mr. Moore's convictions.
All right, it doesn't look as though there are any questions. Mr. Armstrong, you got about 3 minutes and 13 seconds.
Okay, well, I'll go fast, Your Honor. I find it interesting that the state admits that the decedent, and I've been very careful not to refer to him as a victim because he precipitated this entire event, the decedent wanted to fight Mr. Moore. The state does not refute the fact that Mr. Moore was minding his own business in the home of his family. And this is something that the state likes to gloss over. Mr. Moore was at the home of his children. When the decedent showed up at the house, his children were there. His two children were there. So the idea that he wasn't at his own home, he certainly was with members of his own family, namely his children, who he has a duty to care for. Two, the state keeps saying that the decedent just wanted to have a fist fight. Well, we don't know if he just wanted to have a fist fight. That's speculation by the state. And we don't know the nature of the decedent or his ability as a street fighter or his reputation as a street fighter. We do know that he wanted to get into an altercation with Mr. Moore, and he did it multiple times. So for the state to cavalierly state that, well, Mr. Moore really shouldn't have been too upset about this is somewhat illogical. The state incorrectly says that Mr. Moore had a duty to retreat and said he could have gone back into his grandmother's home, apparently forgetting the testimony that the grandmother had ordered, after first ordering the decedent out of her house, who refused to go, just told both of them to leave. because she did order the decedent to leave and he refused. That's in the transcript. She then got fed up and just ordered both of them out, in which Mr. Moore did leave. Now, in fairness to the grandmother, Mr. Moore's children and her grandchildren and her daughter were there, the mother of these two children. So not knowing what this irate decedent was going to do, showing up uninvited and unwelcome at the house on a Sunday night, I certainly can't fault the grandmother for being concerned about the children, but the idea that he had a duty to retreat and could retreat back into grandmother's home is not supported by the record. 5, there's comment that he shot 3 times. I believe this testimony shows it's a Glock 9mm semi-automatic, which means, and we've seen this with police officers sometimes, where they shoot X amount of times when in reality they hit the trigger and 3 bullets go off in rapid succession. The other part made, and I believe it's the case of Stacey Dean, in which the Supreme Court said a number of years ago that thus, in a trial for felony assault where the defendant presents sufficient evidence of serious provocation, and instruction on aggravated assault must be given to the jury. That is cited in both the both my initial brief and the reply brief. So the idea that the trial court would have been abusing their discretion by following the dictates of the House Supreme Court, I do not find that very persuasive. In light of the fact that we have overwhelming evidence and essentially admission by the state that this entire incident on the 31st, and certainly the days leading up to it, if the court takes a second look at that transcript, that after the initial situation with my client, which I admitted, where he fired his gun, the following week, Mr. Moore never sought out the decedent, but the decedent on multiple occasions sought out Mr. Moore looking for a problem. And the idea that he just wanted a fist fight is not supported in the record. We don't know what he wanted to do. All we know is he wanted to harm Mr. Moore. And
that's a good place. With that, your time's up if you want to wrap it up.
Thank you, Your Honor. I just asked the court to reverse this conviction, remand it back to the trial court for a new trial. Thank you.
All right. Thank you both for your arguments, your presentations. We will take the matter under advisement, issue a written decision in due course. It will be mailed to both sides as well as posted on our website and that of the Supreme Court of Ohio. Both of you have a good day.